Welcome to the Trial Lawyers Injury Podcast with David Zagoria.
Welcome to the Trial Lawyers Injury Podcast with David Zagoria of Zagoria Neely Injury Attorneys. David is a former prosecutor who now represents injury victims across Georgia in serious cases involving dog attacks, car wrecks, premises liability, and wrongful death claims. Known for his courtroom experience and strategic approach to litigation, David helps clients understand how injury cases are investigated, proven, negotiated, and tried. I'm Shameika Rhymes, and today we're talking about why some personal injury cases go to trial in Georgia while others don't. Welcome back, David.
Hey, Shameika. Thank you. Good to be back.
Well, David, early in an injury case, what signs tell you the dispute may not resolve through normal settlement discussions?
Well, Shameika, I could give you a legal answer, but honestly, the honest truth is it's when they make a crappy offer. That's usually a good sign it is not going to settle. Now, in all honesty, I kind of know, depending on the insurance company, when we get State Farm, there's adjusters there that I'm familiar with. There's adjusters that I'm familiar with Liberty Mutual. Some of these low-end insurance companies, I know we're going to probably get a lowball offer. I prepare the client for it, and that's fine. Typically, when we get the lowball offer, everything is set up. It's ready to go. We have all the medical records and bills, and we're ready to take the fight to the courtroom. So we just file suit. If we get lucky, they get a new adjuster. There'll be an attorney assigned to the case to represent the dog owner that's paid for by the insurance company. Or if it's a car wreck case, it'll be the driver of the car. If it's a slip and fall case, whoever the property owner is, their insurance will hire a lawyer for them. They're paid by the insurance company, but that lawyer will be a second set of eyes who can perhaps say, you know what, that offer was not very good. We really need to try and get this resolved because this may not be the best case for us to take to trial.
Oh, okay. So what are some of the most common reasons negotiations break down in serious injury cases?
There's really two reasons negotiations break down. And it's really, when negotiations break down, it's really a failure on the part of one side to properly evaluate the case, meaning they are missing something. They're not understanding the true value of the case. And typically that will happen with the insurance company. Now, on occasion, the client may overvalue their case. They may want more than we think is reasonable, but they're driving the ship. If that's the case, that's fine. We're going to support them, or we're going to keep pushing the case to get them the settlement or verdict that they want. But typically it's one side has made a valuation mistake on the case. A lot of times the insurance companies base their evaluation on the medical bills. And that really is an odd way of evaluating the cases. And I don't think jurors really relate to it. And I think it can really come back to bite the insurance company. For example, you may have a car wreck case where someone goes to the emergency room, treats with a chiropractor, has to get an injection, and then they get better and their bills are $20,000. On the other hand, you may have a case where someone's in the same car wreck, same facts, except they have a broken arm. And really the only thing they can do is cast it. And they do 6 weeks of physical therapy once the cast comes off to regain their strength and flexibility and range of motion. And their medical bills are half. Well, which one do you think is more valuable? Which one do you think a jury would say this person deserves a significant amount of money? Of course, it's the broken bone. And so there's not really a correlation between medical bills and the value of a case. And insurance adjusters a lot of times will get caught up in the medical bills and basing value on that. And I think it is a big mistake to focus on the value of the case being related to the amount of the medical bills. I mean, the medical bills are important, but it's not the end all be all in case evaluation.
Okay. Because that just brought up a question of if the person is still being treated for whatever injury they sustained, whether it is the dog bite or the car accident, and the bills keep mounting up, then what? Like, you know what I mean? Does that make sense?
It absolutely does make sense. And it's really an analysis that has to be done on a case-by-case basis. And it has to be very, very You got to be careful with that one. I handled a case not too long ago where the client treated on and on and on, and he couldn't figure out what was going on. The doctors couldn't understand it. No one understood what was going on. And there is a element of what's called Munchausen syndrome, which is a person's getting so much attention by their loved ones, by their friends, that they become not addicted, but the attention becomes something that becomes meaningful to them, and they treat beyond what they should treat. We want people to follow their doctor's directions, find out what's going on. If they're having mental issues, usually PTSD, to see a mental health counselor to get that taken care of, and to get whatever physical issues they have going on taken care of the best they can. Of course, there are clients who are never going to return to their pre-accident state. They're just forever damaged. And they may have lifelong treatment, but there's a medical reason for that. As long as there's a medical reason where a doctor can look at an x-ray or an MRI and say, yep, that's a tibial plateau fracture, that's going to hurt for the rest of their life. They're going to need pain meds. They're going to need PT every now and then. They're going to need to ice it. Then we can build a plan in future for future medical costs so a jury can take that into account. It's when you have phantom pain, pain that's unexplainable, pain that has no objective basis in any of the radiographic studies, that it can become a problem.
Okay, thank you for answering that. How much does the strength of the evidence affect whether a case settles or ends up in court?
So the strength of the evidence is huge in terms of whether it's going to settle or in court. The stronger our case is, meaning the worse the injuries are, the more treatment there was. In a car wreck case, the more upsetting the damage to the vehicles are. I mean, if you look at a picture of a car that's been in a wreck and you think, oh my God, how these people survived, that's very powerful evidence. Whether the doctor is a patient advocate, meaning they're going to relate all of the injuries to the car wreck, the slip and fall, the dog bite, and not some pre-existing condition someone my age might have. That makes for much more powerful evidence. Also, beyond the evidence, you have what county is the case going to be in, because there are counties in Georgia that are way more favorable to plaintiffs than other counties. For example, DeKalb is known as a very plaintiff-friendly jurisdiction. Cherokee County, Bartow County, not so much. Then there are other counties that, are just middle of the road, fair to both sides, like Fulton, Cobb. So that's a very important factor too. That plays into policy limits. So a case with very, very strong facts with policy limits that are reasonable, where the case is close to those policy limits, you're going to get those policy limits. It may be harder, even with great facts, for a case that you value at $1 million. If the policy is $5 million, it may be harder to get them to pay what they should. They may be more willing to fight it in court because there's more on the line for the insurance company because there's just a bigger policy.
Okay. Well, liability disputes and damages disputes can create different challenges in a case. So, which disagreements do you think are the hardest to resolve without litigation?
Well, I think that's a great question. I think it's a blend of how you push the case forward. If you have liability issues and if you have both and you're asking for the moon and stars, you're going to wind up in court. If you have both, but you're sending a very reasonable demand, there's a chance the case could settle. But I guess I would have to go with liability, because if you can't prove the other guy's at fault, in Georgia, we have bifurcated trials and you're not going to get to what the injuries are worth. So if you have a fight over what the value of the case is, whether there's pre-existing injuries, whether the defendant's responsible for those injuries, you may not even get to that. So let me talk to you a little bit more about that. In Georgia, the defense can file a motion to bifurcate the trial. That means first phase, all the jury hears is evidence of fault. Who ran the red light? Who caused the wreck? Was the dog out loose? Who's responsible for the substance on the floor of the Walmart that caused my client to fall? Should they have seen it? These are liability issues. And if you lose on that, say for example, the Walmart one, it's red Kool-Aid on a white floor, and my client just didn't see it, a jury may say, you should have seen that. We're not even going to get to the argument over what the injuries are worth, whether there's pre-existing conditions, meaning if they hurt their back, was their back hurting before? That's a pre-existing condition. If they had a partial tear in their shoulder, and because of the fall of the Walmart, they now have a full tear in their shoulder. We're not even going to get to that if we can't prove liability. So at the end of the day, I got to go liability is the tougher one.
Okay. Well, how much does trial preparation affect the way that a case gets valued during negotiations?
Shameika, that's a great question. What happens, first of all, what happens during trial preparation?
Yeah.
The first step in trial preparation is when we realize a case is not going to settle. It's a pretty good chance we go depose our client's doctor. That can be huge. If the doctor's a client advocate, if he is certain that the injury is caused by the accident that we are claiming hurt our client, that is super helpful. What we like to call those doctors are strong patient advocates. They are in our client's corner for whatever pain the client is experiencing being a direct result of the injury, meaning causation is what we call that in the legal world, is that the injury that my client is complaining about was caused by the defendant, and the care is reasonable, the amount of pain is typical, and so we have a doctor in our corner. That can cause the insurance company to reevaluate and make a new offer. After that, the trial preparations aren't public to the insurance company. They don't know what we're doing. What are we doing? We're doing a mock trial, meaning we're actually trying our case to a jury of people who are just in the community that come in and we pay them and they hear the case. They don't know who we are, whether we're the plaintiff's attorneys or defense attorneys, and they will render a verdict, which will help us. They will tell us what's wrong, if they have issues in terms of liability, so we can flesh that out. The next thing that will happen that the other side is aware of is called the pretrial order. And the pretrial order is sort of like the playbook when you go to a play. It tells you the acts, who the actors are, and for a lawsuit, it's who the lawyers are, who the witnesses are going to be, so the judge can anticipate the length of the trial and everybody knows what the evidence is, who's going to testify, what evidence is coming in, and what the legal issues are. When the other side sees that, a lot of times it will cause them to reevaluate and possibly put more money on the case. And typically, there's a saying that the insurance company doesn't really find their wallet until they're faced with a jury. Is exactly true. We've had many, many cases that we thought were going to go to trial. We get to the courtroom, we start picking a jury, and it's amazing how the insurance company finds more money once they see me picking a jury and establishing rapport with a jury, and the jurors start forming a tribe that I'm in charge of and that I'm leading, that they'll find money that will satisfy my client.
Mm-hmm. That is interesting how that happens. It's like magic.
So, it's amazing how they find their wallets when they're staring at a jury.
Well, can you share an example of a case where the decision to prepare for trial changed the direction of the negotiations?
So absolutely. So one of the better cases we had that changed the whole nature of the case was I had a client who was knocked down by a dog and it caused a fracture to her arm. But she was an older woman. She was in her 70s and there was evidence of osteoporosis in her arm. From the x-rays of the other arm, they could really see that. And the doctor, when I deposed him, was an amazing patient advocate. He testified about, he had to put a plate and screws in her arm. And he testified about how this was going to accelerate arthritis in her arm, that she may have to have it out because she was complaining about the pain. So there was another surgery. He knew how much the surgery was going to cost, which is helpful. And he completely backed up everything our client said about how much pain she was still in. He was so impressive. He was so charismatic that the case settled a week or two after the doctor was deposed. He was just amazing. And she did wind up having to have the hardware taken out of her arm.
David, from a trial lawyer's perspective, what separates strong injury cases from weak ones once they reach a courtroom?
Most trial lawyers would tell you it's the extent of the injuries, it's the medical bills, it's the county where the case is, what judge you're in front of, the skill and experience of the defense attorney. And I agree with all that. But what I would like to add, which a lot of attorneys overlook, is does the client have the ability to be vulnerable with the jury? What do I mean by that? It means they're able to share how this affected their life, and not in a whiny way. Nobody likes that. I want my clients to be like Rocky. They're working hard to get better. We can root for them. But if they can talk about how this injury has robbed them of some joy in their life, all of a sudden the jurors then begin to empathize and relate to them. I'll give you an example. I have a client who went to trial and testified, and she was very stoic, and she was very much that she said she'd gotten better, that she'd moved past this. And when I asked her, what about this has changed your life in terms of what brings you joy? She got real quiet and she got real slow. And she said, I used to love to garden. She had suffered a broken wrist. And she said, I can't carry my pots with my plants in them. I can't carry the bags of dirt. And the joy of gardening has been taken from me. And it hurts me every day because I go in my backyard. I'm never going to give it up. I'm always going to try and garden, but it's just not like it used to. And every time I have a hard time doing it, I'm reminded of my injury and what I went through. And we had pictures of beautiful gardens that she had done. I mean, it looked like the gardens of Versailles in France. And the jurors, not all of them were gardeners, but those jurors were thinking about the things they loved. The golfers who were thinking, oh, I couldn't imagine what it would be like if I couldn't golf. The people who fish, I couldn't imagine if I couldn't fish. The people who love to cook, I couldn't imagine if I couldn't stand on my feet for a couple hours and cook. All related with what she was talking about, having what she loved taken from her. And we got a massive verdict that the defense never expected, because all they were focused on was how much were the medical bills and what exactly was the injury was. What exactly the injury, what body part was injured. So I would say that is the golden ticket in a personal injury case, is having your client being able to be open with the jury, so that the jury can empathize with them about what matters most in life that has been taken.
Wow, that's powerful. Thank you for sharing that, and thank you for sharing all of your knowledge today.
It's been my pleasure. It's been fun. Thank you so much, Shameika.
That's it for today's episode of the Trial Lawyers Injury Podcast with David Zagoria. If you'd like to learn more about David and Zagoria Neely Injury Attorneys, visit lawzagoria.com. Thanks for listening, and don't forget to subscribe, leave a review, and share the show with someone who may need trusted guidance after a serious injury.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.